On the slopes of Diamond Head. This is Kapiolani Community College. Kulia ika nu'u. Strive for the highest.
Aloha, I'm Ben Carroll. Welcome to BLAW200, Legal Environment of Business. We'll be talking about contracts again today. We'll wrap up contracts. So last time we looked at how to form contracts, how to interpret contracts. Today we'll be looking at performance, and we'll be looking at what happens when somebody breaches a contract. But we'll start, as always, with a look at our review. So what do we mean by formal contracts? And what are some of the contracts that fit this description? Okay, well, contract under seal would be a formal contract, but as we discussed last time, we don't usually seal contracts much anymore. That's kind of an old style thing. Some still are done, but for the most part, contracts are treated the same, whether sealed or not. And again, the UCC and state of Hawaii and many other states no longer provide any differences with a contract under seal. Now, what are some other types of formal contracts? Well, in a couple sessions we'll be talking about negotiable instruments, and you're all familiar with that even if you're not familiar with the term, because we use checks and or promissory notes. So those are negotiable instruments, and those also have to be in writing. So certain things do have to be in writing. Okay, what is the statute of frauds? Why do we use it with certain types of contracts? And how does the parole evidence affect our contracts? Okay, the statute of frauds is, again, a common law statute, but it's been enacted in virtually every jurisdiction, and a lot of it's also been incorporated in the Uniform Commercial Code. Again, something that we'll talk about in detail shortly. Statute of frauds in common law provided that specific types of contracts had to be in writing. So we're talking about real property has to be in writing. We're talking about contracts that cannot be completed within a year have to be in writing. A contract for the sale of goods over $500 have to be in writing, and agreements in contemplation of marriage. So that last one's probably not applicable to most of us that won't really need a prenuptial agreement, and very few people are worried about dowry anymore. But again, those are the common law provisions. Why are these selected for having to be in writing as opposed to other instruments? Well, these, at least at common law, were major kinds of deals. $500 in the olden days was worth some money. Obviously, dealing with real property was important. And the other ones were things that seemed to be problematic, where we would expect there might be disputes arising, and we were concerned actually about proof. So certainly something that can't be completed in a year, more likely problems will arise over time. So we want those to be in writing. Now, the parole evidence rule, parole is just another word for oral. So the parole evidence rule indicates that if we have a writing, we will not allow oral testimony to contradict the writing. Okay, now this writing doesn't have to be a nice, formal, put-together document, but it does need to be some evidence of the required terms that we expect in the contract. And so we do want that evidence to support the contracts that need to be under the statute of frauds. Now, we can't contradict a contract with parole evidence, but you recall we may be able to explain, or in some instances supplement, what's in the writing if we're not contradicting, if we're actually just explaining. Okay, what do we mean by the genuineness of assent, and what factors may affect this? Okay, this takes us back a little bit to contract formation. So when we talk about genuineness of assent or mutuality of assent, we're talking about, did the minds meet? Were we talking about the same thing? So have we actually, in effect, formed a contract? Or if the minds didn't meet, then we may have a voidable contract. So what are the kinds of things that can affect that? Well, it could be certain mistakes will affect this, fraud will affect this, misrepresentation, and again, influence on the other party to cause them to enter into a contract when they might not, such as undue influence or duress. So any of these might reflect on whether or not there has been a genuine meeting of the minds, and so there may not be a contract formed. Okay, now if the execution of a contract is procured by fraud, what can the injured person do, the innocent party, so to speak? Well, in this instance, what we would do is we would rescind the contract. So this would be a voidable contract. And if the person can show that they were enticed into entering into it due to a misrepresentation of a material fact, then they would be able to get out of that contract. And you recall, material fact we had talked about previously, and that was a fact that would cause them to enter or not enter into a contract. And so if there has been a misrepresentation of material fact, then they would be allowed to get out of it. Okay, will a mistake justify canceling a contract? And what is the difference between duress and undue influence? Okay. Well, only certain kinds of mistakes will allow us to get out of a contract. Generally, if there's a mutual mistake as to the subject matter, both sides are confused as to the subject matter, then that would allow us to get out because we haven't had that definiteness of the terms and the meeting of the mind. So you recall one of the classic examples was a ship, two different ships with the same name. So they were mistaken. They were not talking about the same ship. Okay. Normally a mistake as to value will not allow the contract. So it's got to be the subject matter, not the valuation. Okay. How about unilateral mistakes? Well, generally, if one side is mistaken, that's still enforceable by the other side. Okay, there are some exceptions if somebody has been induced, there's been misrepresentations, or the other side knows that they're mistaken about something important and allows them to continue to think that. So there are exceptions to that, but generally just a unilateral mistake won't do the trick. Okay. We talked a little bit about duress and undue influence. So duress is where the other side, in essence, is threatening, and that can be physical, or that can be emotional, or that can even be economic. So if the other person is in kind of a no other option position, then the duress may allow the innocent party to get out of the contract. Undue influence is not so much a threat, it's just an ability to influence the other side, and this involves out of position of trust or fiduciary relationship, and one party is in essence dependent on another party, and that party takes advantage of them and talks them into or causes them to enter into a contract. So that may allow someone out as well. Okay, if standardized or pre-printed provisions, and we call those boilerplate, are different from negotiated provisions, which provisions are given more weight? Well, the court favors negotiated terms. So the court wants people to talk it out and to come to an agreement. Again, that meeting of the minds. So it's going to look to see what indicators there are of something having been negotiated. So certainly if you have something handwritten in, fill in the blank, that would take precedence. That would be more important than something typed. Okay, and something typed would be more important than the pre-printed type of thing. So the small print may be enforced, but if there's something else handwritten that indicates differently, they're going to take that into account. That's going to be primary. So they will look to see whether it's been negotiated and whether or not there's indications of what should be more important. And again, it's the negotiated terms. Okay, well, today we're going to look at enforcement of the contracts, we're going to look at privity, a term probably you're not familiar with in normal conversation. We'll be looking at performance. We'll look at breach of contract. You recall, breach means that there has been a failure. So when we talked about a breach of duty, we meant a failure to do your duty. And similarly, a breach of contract is a failure to comply with your obligations under the contract. We'll be talking about the types of damages. We'll be talking about mitigation. So mitigation is a responsibility on someone who has been injured or who has not received performance to do what a reasonable person would do to avert or reduce their losses. And then finally, we'll talk about some equitable remedies. So again, when we talk about damages, we're talking legal remedies, but recall that the court always has the ability to do what it thinks is fair, and that's the equitable side of the law. Okay, so looking at privity, what is privity? Privity essentially means that contract law is going to govern the rights between the people to the contracts. So the rights and obligations in the contract accrue only to the parties to the contract. So contracts certainly can affect other people, but generally the rights under the contract, the ability to sue on and enforce the contract, is going to be limited to the people, the parties to the contract, the people who signed. Now, occasionally there will be third parties that do have some rights, and we'll be looking at those. But again, privity means that the right to enforce is limited to the parties. Okay, so what are some of the exceptions to privity? Well, we have what we call assignment. Assignment of a contract is a transfer. And we have some intended third-party beneficiaries. And again, when we use the term third party, we are talking about people other than the parties to the contract. So there are certain instances with assignment or with intended third-party beneficiaries where these third parties do have rights. Okay, so let's look at assignment first. Okay, an assignment is a transfer of rights that allows a person that's not a party to enforce the contract. Okay. Normally in a contract, there is the right to assign, so you can assign your duties or assign your rights or delegate your duties. And there are some limitations on this, and the paramount one probably is if it has to do with personal skill or personal ability, then you would not be able to transfer that. So what do we mean by personal skill? Well, a personal service would be perhaps if I wanted to have my hair done by Mr. Baboo's and he wanted to assign that to someone else in his salon or another hair person. I may want it done just a certain way, and even somebody else qualified and apparently of the same level of skill or whatever, just wouldn't be the same. I have hired a particular person, I've contracted with a particular person to do it. Someone else isn't the same performance. So it's not an objective standard there, it's whether or not it is a personal service. Okay, what are some other things we can't assign? Well, we can't assign a future right. So if something is non-existent at this point, it would be confusing to have that assigned. If the assignment would materially alter the risk, in other words, by assignment, I am in essence giving less to the other side because of circumstances. And finally, legal action involving personal rights. So you can see a lot of this has to do with not allowing the transfer of these obligations and rights if that's going to alter what was contracted for. So if the essence of the contract involves particular people, we're not going to allow it to be transferred, even though we might argue that the transfer actually should be considered the same because of skill or whatever. If it isn't to the people involved, then that might be grounds to not allow assignment. What's the effect of assignment? Well, if in the instances where we allow assignment, the assignment literally transfers the rights to the other party. So the assignee, the person receiving the rights, stands in the same shoes, stands in the same position as the original. So the person that's obligated to perform for them, that's transferred to the new person, okay, the assignee. Now, if the assignment is legal and it's unconditional, that means that the original person that was entitled to performance isn't. So the S&R, the person giving away or transferring the rights, no longer has any rights. Those rights have been transferred in total to the new person. Okay, so if we look at, for example, a promise to repay, someone has loaned money and there's been a promise to repay, we can see that that is a kind of contract, generally, since there's money involved, that we can transfer. Okay, and if we transfer that, you can see that the original person that's entitled to receive the money transfers that right to receive money to a third party, and that would be the assignee. Okay, now the assigner no longer is entitled to receive the money. Now the assignee is entitled, and so the assignee now can bring an action against the person that's supposed to pay, as opposed to the original receiver. So you can see that's the kind of right, since it's involving money, it's not a personal service kind of deal, that we can transfer that, and now the obligation to pay has been transferred to another person. And you'll find, people will find this particularly with negotiable papers such as promissory note or a mortgage or various other kinds of instruments. These can be transferred to other folks, and so those assignments are really quite common. Okay, now the other thing we talked about was third-party beneficiary. And again, beneficiary meaning somebody that benefits from the contract and is not a party to the contract. And we have two different flavors of third-party beneficiary. And the one that allows, is where assignments are effective, is an intended third-party beneficiary. So this means that in the contract we intend to and note that this person is a person meant to benefit from the contract. And we'll talk about some obvious examples. Okay. Now an intended third-party beneficiary, like an assignee, receives the benefits and is entitled to sue on that rather than the original parties. Okay, so incidental, on the other hand, there's also an incidental third-party beneficiary, and this is simply someone that benefits from the contract, but they're not part of the contract and they're not intended to be involved in the contract. So what might an example of this be? Well, if you contract with a builder to build a house for you, and you express an interest in having a particular architect do that, or maybe even note the architect, but if the builder does not use that architect in the design, your problem is with the builder. Okay, the architect, although they would benefit from receiving this business, is not part of that contract and is not an intended beneficiary such that the architect could now sue the owner. Only, or the architect could, yeah. So the owner at that point only has the relationship with the builder, and if the architect isn't hired, the owner goes against the builder. Okay. Now the ones that we're interested in, again, are the intended beneficiary. Let's take a quick look at how that works. Okay. Now this would be, for example, in a will, and we don't think of a will as a contract, but it's useful here as a way of looking at it, is our will is kind of a contract with the state, and it indicates that when we pass away, the state has agreed to distribute our assets to the people we indicate. In other words, to the heirs or the intended beneficiaries. So we will note what we want to happen with our assets. Now here, of course, you can see logically we're not going to be able to bring a lawsuit after we're dead, so the intended beneficiaries are, in fact, the only people that would be able to bring an action on that. Okay, and very similarly would be a life insurance policy. So I have contracted with a life insurance company, and I pay them premiums, and they are going to provide life insurance benefits after I'm dead. So again, I can't be bringing that action. So who could bring the action? Well, the action is going to be brought by the designated beneficiaries, the third parties that I've indicated where this money should go. So you can see these are very similar. And of course, you can have an intended beneficiary even if the original obligor does not die, but this just kind of makes it a little more obvious. So if you have a valid claim under a life insurance policy, the beneficiaries can bring that action against the insurer even though they were not parties to the original insurance policy. So again, if we look at how that looks, you can see it's very similar. So the contract itself is between the insured and the life insurance company, and they have indicated who the named beneficiaries are. So after the event happens, the insured dies, if the company does not pay a valid claim, then the third-party beneficiary would be able to bring an action to enforce that insurance policy, that insurance contract. Okay, so we're going to use the term discharge, and discharge really just says that the contract's been terminated, and there's various ways that we know the contract is over. In other words, the contract has been completed. So the obvious way is performance. So what we mean by performance is the contract has been performed, hopefully fully by both sides, and so now it's over. So whatever it is has been exchanged, the service has been done, whatever the obligations and duties are on each side have been finished. Okay. Another possibility is we can agree to terminate or discharge by agreement. So there's various kinds of agreements we can make that the contract is POW or we're satisfied with it, etc. Okay. There's also impossibility, impracticability, and frustration. So there are things that can happen that will affect whether or not the contract can be performed at all. And so it may be terminated by something that's happened that we didn't have any control over, was perhaps not foreseen, and in that event the contract may terminate even if it hasn't been completed and even if the parties did not agree. Okay, there are certain instances where the law will terminate a contract. So we can imagine something occurs where the law says this contract now is not going to be allowed to go to completion. Okay, and then finally, a contract can be terminated by breach. So in other words, breach meaning that one side has not performed or is saying they will not perform, and depending on that failure, that breach, that will terminate the contract and start perhaps some other enforcement at that time. So let's take a look at some of these in a little more detail. Okay. When we talk about performance, obviously we have complete or full performance, which means that the parties have done what they said they were going to do. But there's also the possibility of conditional performance. And so these are instances where something has to happen before the contractual obligations occur, or something happens and then the obligations terminate. So we talk about condition precedent, in other words, a condition that precedes the initiation of rights and obligations under the contract, and conditions subsequent, which means that something else can happen that ends the duties. So if we talk about a condition precedent, we'll just use a single example, but you can say, as soon as you get your license to drive, I'll hire you as a driver. As soon as you get your license to practice law or medicine, I'll hire you as a whatever. You can see that the obligations do not come into play until that condition precedent is effective. Whereas a condition subsequent means I will perform until such time as some other event or circumstance happens, and that will end my duties and obligations under the contract. And the example on this would be I will pay child support, or I will pay such and such until you get divorced, or until you marry, or until something else happens. So in that instance, that would end my duties and obligations. So you can see we can set provisions to indicate how long a performance will be required. Okay, we also talk about substantial performance and satisfactory performance. Substantial performance means that we may not have fully performed, but we've done enough. In other words, the law reviews and says close enough so that you should keep the contract in effect. In other words, it hasn't been such bad performance that the contract would be terminated. Now, we may still have rights if we've done substantial performance. The other side has done substantial performance. We may still have rights to recover because they didn't fully perform. So there may be some damages for not fully performing. But if it's substantial performance, what we're saying is it is enough that the law will enforce the contract, and so the duties and obligations will be continue. Okay. Now, if there's not substantial performance, it means not enough's been done where that we think that there's worth keeping this contract, so we'll have other options, but we're not going to enforce it. It's not enough performed. May not be maybe non-performance. Nothing's been performed on the other side. Okay. Now, in terms of satisfactory performance, there may be contracts where that there's not an objective, so to speak, indication of whether it's not paying money or something like that, but perhaps we are asking to have something done to our satisfaction. So we're having a painting done of our family, or we're doing something else where it is meant to be aesthetic. It's meant to be something that the other side has agreed to satisfy us. Okay. Now, that obviously is a higher standard than something simply we know it's been done. So this may take some looking at, but the court at this point will look at whether or not the acceptance of performance is done in good faith. In other words, they will look at that standard. Is the person that's saying satisfied or not performing in good faith? Now, there may be other instances where we've required something be done. It seems like satisfaction, but it's of a more general type. And what would be an example? Perhaps we're having a roof put on or something done with a building, and we say we want it to be able to withstand the elements. Okay, so again, we're asking that it satisfy a certain kind of condition, but that's a more general condition. It's not a personal thing. Either it does satisfy that requirement or not. And so then we would go back to our reasonable person. Does it reasonably meet that thing that we said? Okay. Okay, now discharge by agreement, this kind of makes sense. This is termination by completing it. Okay, so, or by coming to an agreement when completion has not happened. So we might discharge when both of us just say, not worked out, and both of us are agreed the contract is over. So another possibility is one side releases the other side. So again, this might be a close enough situation, so you would provide a release, and that's saying, I'm okay with the performance I've received. So nothing further required from you. Okay, we might have waiver, and waiver is not express, but waiver is perhaps actions or some other indication by one side that we're not expecting performance or any more performance. So particularly over time, we may indicate that's okay, or some other way we've indicated without expressly releasing the other side, then we may waive performance on that side. Okay. There's possibility of substitution. So that means that either the rights and obligations on one or both sides, we've decided maybe something's changed, so we want to substitute an agreement. We're both agreed. We do want the contract to continue, but we're going to change some things. And again, we do that by agreement. Now, there is novation, which is particularly if we substitute new people, and that's got to be by assent. So both sides are going to need to agree to that as well. Okay. And we talked briefly last time about accord and satisfaction. So this is, the accord is reaching the agreement that performance would be different, and the satisfaction is the other side saying, I'm okay with that. Okay, so again, we looked at this particularly in settling matters last time. Okay. Now, there's a whole range of impossibility by something's happened that we didn't foresee, and so we are going to discharge, we're going to terminate the contract because something's happening that makes it either impossible, impractical, or the purpose won't be not able to be met. So obviously physical impossibility occurs when the subject matter's been destroyed. So for example, if we're going to sell something and that's been destroyed, obviously that can't be completed. So it's impossible for us to go through with that. Okay. Again, we talked a little bit about personal services. There may be changes in the law that render something impossible. So maybe something gets rezoned, some kind of use or some kind of activity is now not legal. So that would make it impossible for us to legally comply with the contract. Okay. We also talk about frustration. So again, things can change, and a lot of times this will only discharge the future performance. The performance that's been done up till that point has occurred. So we're talking about future performance. But again, let's look at some of what we might be talking about. Okay, these need to be unforeseen events. So if it's something foreseeable, we would probably cover that in the contract. So that's a normal risk of business, that sort of thing. So what we're talking about here to terminate the contract would need to be something unusual or extraordinary or not expected. Otherwise, the normal wear and tear kind of things that go on, the normal contingencies that are expected, these wouldn't be grounds for us to terminate the contract. So the court again is looking at what's fair, what reasonable people would expect, that sort of thing. Okay, so a couple of kind of clauses we might put into our contract that would involve impossibility, impracticability, etc., would be what we call a force majeure, and this is a French word meaning superior force. So this indicates that, a clause that indicates that, well, the contract won't be enforceable in the time of war or if a natural disaster makes it impossible, etc. So this is a recognition in the contract that we don't mean to have it continue if it's impossible. Okay. Now again, the court might decide impossibility even without this, but a better drafter would probably want to put something in the contract that indicates what might happen in certain conditions or totally unexpected sorts of things. So you might add these provisions, recommended you say something about it, but they're not always there, and if they're not, the court will look at this on its own. So another possibility is what we call a hardship clause, and we'll be talking a little bit about international contracts, sale of goods when we talk about the sales part of the UCC. And the CISG is the kind of international equivalent of the UCC. And hardship's a term particularly used in some international contracts and by other countries. And this again indicates what might happen if something's not totally impossible, but burdensome and changes the way we look at contracts. And we'll talk a little bit about that. Contracting in other countries tends to be a little bit more fluid and interactive. Many countries, particularly in the civil law tradition, tend to think, well, yeah, that's in the contract, but things have changed, so we should talk again. We should renegotiate. And that's a little, shall I say, foreign to U.S. contractors, but we'll talk a little bit about that when we talk about international. And finally, some people actually use the term of hell or high water clause. And this comes from an old colloquial saying, if something's going to happen come hell or high water, it means it doesn't matter if these natural disasters occur, got to perform anyway. So this is kind of the other side of a clause that simply says, you're taking the risk, and whatever happens, you got to perform. So this is kind of raising the bar and trying to do away with using the impossibility and or frustration doctrines. Okay, now we can terminate or discharge a contract by operation of law. And these probably look pretty obvious why they would work, so we'll run through them. But we're talking about bankruptcy, a material alteration, merger, death if the contract is for personal services, discharge by lapse of time or statute of limitations. So these are instances where the law says you are discharged or not. So if you have go through your federal bankruptcy, and we'll talk about that a little bit in the future. If you go through bankruptcy, then many of your contracts will be terminated. So the other side will not be able to pursue you after you have gone through the bankruptcy proceeding. With a material alteration, the innocent party will be protected. We'll talk about a little bit about this in banking. Okay. Statute of limitations, if you don't bring it in time, this is obviously procedural. So if you allow the statute concerning enforcement of contracts to pass, then you will have lost your right. And in many states, including Hawaii, that's a 6-year statute. So if you wait longer than that, you may lose your right. The law says your contract is terminated. You cannot enforce it at this point. Okay, and discharge by breach. So what does that mean? Well, the contract can terminate when one side refuses to or fails to perform. So actual breach is where there's a time for performance happens and you fail to perform. So the other side, that's now termination. Again, substantial performance changes this, but if you fail to perform and you have not even substantially performed, contract can be over and the other side can pursue their remedies. The other possibility is anticipatory breach, and that means in certain instances the other side, maybe the time hasn't happened, but they are telling you we're not going to. Okay, and you can take certain steps at that point to protect yourself. You don't, in some instances, need to wait until they've failed. You can take other steps to make sure that you're covered, that you're able to continue your business despite their indication they're not going to go through with it. Okay, let's look at contract damages. So we've already looked at damages when we were talking about tort cases, and so some of these damages are going to look familiar to us. So certainly we talked about compensatory damages, we talked about punitive damages, and we talked about nominal damages when we talked about torts. So these have very similar aspects to them, and they are familiar terms with us. But we'll look at them in the context of contract as well. A couple new types of damages. So we will look at the distinctions between incidental and consequential, and we'll also look at liquidated damages, which we include in contracts. Okay, so if we look, you can see, again, the compensatory are categories in both torts and contracts. On the tort side, we had general and special damages. On the contract side, we have what we call incidental and consequential, and we'll look at those. Okay, we did have punitive damages in torts, and you recall that they weren't that common in torts because they required that there be egregious conduct, reckless disregard sort of thing for punitive damages. So they weren't really even that common on the tort side, but they're extremely rare on the contract side, almost non-existent for most of us. Okay. Now, there were equitable remedies in addition to damages, and the equitable remedy we talked about on the tort side, and again, equitable is where the court usually tells somebody do something, don't do something, and on the tort side, that was generally an injunction. So you recall in intellectual property, we could enjoin someone from revealing a trade secret, we could enjoin them from publishing a book that was defamatory about us, that sort of thing. So that's the equitable relief we saw on the tort side. And there are quite a few other equitable remedies that we'll see on the contract side. So there are abilities to do away with the contract, to reform or change the contract, and something we call specific performance, so requiring a certain kind of performance in the contract. And then we've also added liquidated damages that we'll talk about. Okay, so compensatory damages are damages, as they were in torts, that are meant to bring the person back to where they would be except for the failure of the other side. So in a contract, the performance we expected and did not happen, we will compensate for what we would have received. Okay, so we call that the benefit of the bargain. So we can recover for what wasn't performed. And again, when we talked about substantial performance, contract may still be there, but we didn't get all we were supposed to. We can recover for that. Okay, now the consequential part of this are the foreseeable damages, and they come right out of, they're directly related to what was meant to be performed. Okay, so we will look at those damages. Incidental are the damages that come right out of the incident. Okay, consequential damages are the damages that are foreseeable, that come out of the contract, that we knew would happen but aren't directly related. So we'll look at an example to make that clear. Okay, mitigation of damages means that the non-breaching party, in other words, the party who has been damaged, does have a responsibility to lessen their damages. So even though the other side has caused some injury, the party being injured can't sit there and continue to be injured when a reasonable person would take steps to stop that. So there is a responsibility on the innocent party, the non-breaching party, to reduce or lessen their damages if that's what a reasonable person would do. So some examples of this are, if you have been wrongfully terminated, then you have an action against the person that's terminated you, but you would be expected to do what a reasonable person would do, which would be to get a job. Another example might be if you have a contract for sale of goods to receive goods, the other side does not send them, and you are incurring losses because you have people you're supposed to supply, then you would be expected as a reasonable person to look around, see if you can obtain them someplace else, and to meet your other obligations. Now, of course, there would be damages there, but you should be reducing your damages if that's what a reasonable person would do. Okay, so we would look at our incidental damages, in other words, the damages that come right out of the incident, so the loss of the actual contract performance. And then we'd also look at the consequential damages, in other words, the damages that were reasonably foreseeable that might arise out of a breach of contract. And then we would crank in the mitigation, and that would give us our compensatory damages. Okay, so let's look at a situation here. You can see we have a roof that's not in very good shape, so need to be some repairs here. And let's say that this is coming on the rainy season, so we know that we're going to have some storms. We know that it's going to get wet. So the sunny weather is going to give way, and we're going to be concerned about the rain and what might happen with our roof not in good shape. So we may make a deal with we may call up the roofer and say, season's coming up. We're expecting a lot of rain, so we'd like to have our roof repaired. And what if the roofer says, fine, but we got an awful lot of business right now. We'll get to you when we can. Perhaps you even pay a premium. So perhaps you say, can you put me a little farther ahead, expedite it. And so maybe even you pay a premium to have the roofer come and do the work early so that you'll be covered when the rainy season does come. Okay, so you've hired the roofer comes, does the work. Again, you pay a premium. They put your roof on for you. They may or may not give you any particular guarantees. We will be talking about warranties, etc., in a future session. But in any case, you've hired the roofer, you've paid a premium to have it done on time, and they have done that. Okay. Well, what happens next? The rainy season has arrived, and we are not happy with our results. So, we're inside, and we still are having trouble here. So, we didn't get what we paid for, did we? So, So, what are our options? Well, we've obviously had a breach, so we have not received what it is we contracted for. And we are sitting here, we're getting wet, and so what would be our incidental damages? Well, our incidental damages would be we contracted to get a good leak-proof roof, and we didn't. So how would we gauge what are we owed to compensate us? Well, to compensate us is to give us the benefit of the bargain. In other words, it's to give us a good roof, a weatherproof roof, which we did not get. So has there been substantial performance? Well, probably depends. But in any case, we are entitled to have a good roof because that's what we've already paid for. And you recall we've actually paid a premium for it, but we're entitled to get a good roof. So how do we go about that? Well, we may not be satisfied with this particular vendor. We have some possible remedies. Do we want them to come back and fix it? Okay. Do we trust them to fix it? Okay. Would we rather they pay and we'll get somebody else to fix it? Okay. Can they fix it with the next storm coming? Okay, because this is rainy season, another storm's coming up. Can they fix it in time? Do we trust them? Do we want to hire somebody else? So there's some possible remedies there. Let's say that, and that's our incidental damage, was to get the roof we bargained for. But remember, we talked about consequential damages. So what are consequential damages that arise out of this contract? In other words, foreseeable damages. Well, perhaps we have some valuable things in our house that have been damaged by the rain coming in. Perhaps we brought home some merchandise from work that we're keeping there, or we have other things we're storing there, and these things have been damaged. Well, are we entitled to consequential damages for the amount of money we've lost in these things that have been hurt by the rain coming in? Certainly a consequence of a leaky roof is that things inside will be damaged. So assuming this is foreseeable, that we will be having things in our house damaged, then this will be consequential damages. The other side might argue whether or not if we had something extraordinarily valuable that was foreseeable, and that might be a question. But certainly a leaky roof leading to water damage to things inside a house, that's certainly consequential that we would be expect to recover. Now, how about the issue of mitigation? Okay, so they've given us a crummy roof. Our stuff's being damaged. We know another storm's coming. We're not able to get the roof repaired either by this firm or another firm in time. So do we have any responsibilities, or can things continue to get damaged and at the end of it we'll sue them for everything? Okay, here's where mitigation comes in. So if we know another storm's coming and we still have undamaged things, that might be damaged with future water, wouldn't a reasonable person remove those things, cover them, put something on the roof, do something? And probably the court would say a reasonable person would take steps to reduce future damage. In other words, to mitigate damages that might come. So that would be an instance where we might have mitigation of damages as well. We might have to take our own steps, even though this all results from their failure to perform the contract. Okay, so liquidated damages. We will use the term liquid. You've probably heard of liquidation sales. So when we talk about liquidation, we're talking about turning something into money. So a liquidation sale, and we'll actually use the term when we talk about bankruptcy. Okay, but basically by liquidation we mean turning an asset into money, turning something into money. So what are liquidated damages? Well, Liquidated damages are when we estimate what might happen in the event of a breach of contract. So we know that there's some losses that we're going to incur, and it may be difficult to estimate those. So we have put an amount in the contract that is a reasonable kind of best guess of what our losses would be if the contract is breached by the other side. And there is a requirement in the law that it not be a penalty. In other words, it not be an arbitrary number stuck in to say, if you breach this contract, you will pay us $1 million. So it has to be some kind of reasonable look at what the damages might be. So what would be some examples of liquidated damages? Well, when we're talking about time being of the essence, we're talking about where the importance of something happening at a certain time. So when we talk about a time is of the essence contract, it means that the timing is very important. And this might be the case in a construction contract. So certainly in our contract to fix our roof, if we know the rainy season's coming, we might say, as closer we get to when we know the rains are, the more likely we're going to be damaged. So we might put in a provision that says this contract should be performed by X date. For every week that it's not finished, you will pay us X amount of money. Okay, so we might have some kind of provision like that. Something similar might be if we're opening a nightclub and we're doing a lot of advertising, and if we don't, if it doesn't open on time because of zoning or somebody building or whatever, then we know we're going to incur the damages for publicity, etc. Of course, there may be other damages for loss of reputation, etc., but certainly there may be an estimate we can make that if it doesn't happen when it's supposed to, we'll incur some damages, and this is a reasonable estimation of those damages. So by liquidated damages, we mean an amount put in the contract, so expressed up front, that will pay in the event of a failure to perform on the other side, so pay for a breach. And this is different from our normal damages, because normally we don't learn our damages till after the fact. And this is a pre-estimate, an estimate in advance, actually stated in the contract, of what should be paid if performance does not occur. And you can see that would be quite an incentive to meet your deadlines, etc. Okay, now equitable remedies. Again, these remedies are not the damage remedies. These are the other things the court can do based on fairness, etc. And so they also are meant to prevent one side from benefiting when it shouldn't, particularly if it's done something wrong. So again, these are similar to our injunction. In other words, to take care of matters that the law doesn't feel legal remedies, damages would do. Okay. So in the case of contracts, there's several of these, whole string of R's you can see: rescission, restitution, reformation, specific performance, promissory estoppel, and quasi-contract. So the last two of these, actually, sometimes people don't consider remedies. These are looked at in advance to even see if we have a contract, but I think they make sense to put them all here. Okay, so rescission and restitution. Rescission we've already talked about. So rescission is the undo the contract and try and put the parties back the way they were before the contract. So certainly if there's a material breach, fraud, undue influence, or mistake, in other words, if a contract should never have been, didn't form, or shouldn't have been allowed to form, then the court will try and put the parties back the way they were without a contract. In other words, make it as it was before. Okay. Now, restitution means that in certain instances, again, we've used this term even in the when we talked about the criminal law. This is to kind of pay back what was lost. So if we rescind a contract and somebody has paid money over or done something that can be returned, then we would have that returned. So remember we talked about when minors enter into contracts, if that contract is terminated, is voided, we would expect the minor to give back what was obtained. Okay. Okay, specific performance. Specific performance, again, is an equitable remedy, and this is where the court says that damages would not be sufficient. So typically this will involve a sale of something that is so unique that the money value of it just isn't the same. So what would be an example? If you bought a famous painting by Picasso or Van Gogh or whoever, and the other side would not go through with it, the court might order that they go through with it because the money value isn't the same. It's kind of like the personal thing. This is something, that's what you wanted. There's no other possibility. Certainly all land is usually considered to be, so a contract for sale of land, it's possible that specific performance would be granted because each is considered to be unique. And that's a key feature, is that it's something unique. The other thing is this is not for services, it's only for goods. So for the same reason we talked about before, they're not going to enforce a personal service. And so if you wanted to hire a famous chef to cook a birthday dinner, chef said, I don't want to do it, think about it. You want to eat something cooked by somebody who didn't want to be cooking for you? So, I mean, there's just some practical concerns there. Okay, promissory estoppel. And this, in essence, prohibits somebody from revoking a promise. They're stopped from revoking their promise because the other person was induced or relied on them in entering into this. Okay. It particularly applies when there's a relationship and that this reliance has been engendered on one side to perform. Okay, and quasi-contract is simply a device where the court says we're going to find a contract even though there wasn't one. Okay, because otherwise would be unfair. It would allow one side to benefit, so we're going to say there was a contract, and so there has to be performance both ways. Quantum merit simply means that if you have performed a service, it's not a volunteer service. There's an expectation that you should receive compensation, that you will be allowed the amount of compensation that's reasonable for what was performed. Okay, and I'd like to leave you with just, as we leave contracts, just the idea of kind of step-by-step to go through and look at your agreement and see, is there a contract, so we know what those terms look like. What do the terms actually say? Remember, there has to be certain definiteness. Is it valid and enforceable? Did we have a meeting of the minds? Was there a genuineness of assent? Has it been discharged? And you can call it can be discharged by performance, by agreement, by operation of law. And then has there been a breach, the other discharge? And then, of course, we'd look at our remedies. Okay, so that wraps us up for contracts. We will be talking a little bit more about some aspects of contracts online. So our next time we'll be looking about online. Would you do look at the materials? Again, we cover quite a bit, and so some of the exercises and the reading ahead will help you understand what we are going to be looking at and kind of get it into your memory banks. So this has been Carol saying aloha. We'll see you next time, and we'll be looking at e-commerce, and we'll be looking at interactions on the internet. See you then.